What's up, everybody? Welcome back into a case we haven't talked about in a little while, but a lot of people have had questions about just what's going on between the plaintiff's lawyer in the Take Care of Maya case. Post huge verdict, big win, everybody's hugs and kisses until we start to see some motions come through publicly discussing issues that seem nefarious on their face. And after more of the motions have been filed and we've got the judge's order now on what he's going to do as far as which lawyer is going to be able to withdraw and how they're going to move forward with what lawyers, it's time to answer your questions. We're going to read through those motions, read through the judge's orders, read through the responses so we can get an idea of what's going on behind the scenes. Just after reading Whitney's motion to withdraw, I wasn't so sure I wanted to talk about this because there would be so much speculation and I really wouldn't be able to know exactly what the claims or arguments would be. But now that we have more information and we've got a judge's order, I feel more comfortable discussing what I think is going on behind the scenes with the lawyers in the Take Care of Maya case. So we're going to start with the first document that was sent to me by all of you and kind of spurring the questions. And that is Nick Whitney's motion to withdraw as counsel. And you'll see kind of why I was apprehensive to jump into this at first when we start to see the issues that Mr. Whitney discusses in this motion. This is not to be taken lightly. This is not something that plaintiff lawyers often do or say to each other, especially after we have a huge victory, hundreds of millions of dollars in a verdict. But, and I see some people saying money changes everything, but what I'll say is this is also going to be a lesson and a discussion in what really happens in civil cases and how big corporations and companies sometimes try to discuss things to media and boo-hoo when a lot of times they don't pay $1 or they pay a lot less than whatever that verdict was, even though they say, oh, this verdict is so unfair, or they just hold out. They make you wait. And you see with motions like this, how things become more difficult with time. Regardless of what you feel about the case, Maya and her family won. Johns Hopkins lost. They owe Maya money. But there's an appellate process. And this is something that we explain to clients before we go to trial. Depending on what the offer is, we say, listen, we can go to trial. We may get more than this, but you have to be aware of X, Y, and Z. And X, Y, and Z is usually we could lose or we could win. And if we win really big, you can guarantee there's going to be an appeal. And what does an appeal look like? It looks like dragging it out and taking a lot of time, which is what's happening here. So let's take a look at this motion to withdraw filed by Nick Whitney. Undersigned attorney Nicholas P. Whitney hereby moves the court to withdraw as counsel for plaintiffs Maya Kowalski individually, Jack Kowalski individually, Jack Kowalski as personal representative, the state of Beata Kowalski. The undersigned moves to withdraw based upon good cause. Now, you could say irreconcilable differences. You could say a million things, right? We have read motions to withdraw before in writing. That's how it should be done. The judge makes a call, especially when you're deep in litigation, and the judge moves on. But that's not what we have here. He's going to give us some deets. On July 9th, 2024, and by the way, this was filed on July 24th. So this stuff was actively happening. It's about a month ago. On July 9th, 2024, I raised concerns with Mr. Anderson over his refusal to provide a closing statement. So let's take that one first, right? It's a list of issues. To provide a closing statement, when I first read this, I see that as a settlement statement for the case. Meaning you settled, let's say it's $100 million. Let's say the fees are, I don't know, $20 million. However, they divvy that up because it's a sliding scale, starts 40%, 33%. It goes down as you go up in money in Florida. So let's say they got $20 million as attorney's fees. They paid, I don't know, a couple $1 million in medical bills, a couple $1 million in costs. Maya and her family get $70 million. I'm just making up those numbers. That would be the closing statement. And he's saying Anderson is refusing to provide that. That would be an issue because a lot of people are owed a lot of money in this case, right? It's not just the victims, the lawyers, the experts, the doctors, court reporters, maybe, whoever else you used and paid money to, a lot of people are owed money. And that's why the closing statement or settlement statement is so important. But I don't really think that's what that is. After continuing to read on and not really getting any more information, I think it may be a closing statement dealing with something else, even though that's absolutely what it sounds like on first read. Next, his failure to notify our appellate and referring counsel, in this case, of the receipt of settlement and financing proceeds. Okay? So, we know that we don't know, right? We never know anything really, okay, about what's going on behind the scenes. And this is just my best guess and opinion based on, what we're reading in my experience as a plaintiff's PI lawyer here in Florida. So when he says settlement and financing proceedings, we're going to talk a lot about financing in this video, specifically in PI cases. But he says settlement proceeds. So one of the questions I have is, I believe we know they settled with one of the doctors. Her name just slipped my mind, but you guys all remember her. We broke down her testimony. So they did settle with her. I think it was a couple $1 million settlement. So it's not unusual to disperse partially a settlement like that, especially when you're waiting for this money. And when you disperse a settlement like that, there's a number of different ways that money can go. Again, usually you pay your attorney's fees out of that settlement money. Let's just say it's $2 million. You would pay your attorneys the $700-ish thousand that you owe them. You would pay, again, medical providers that you had to. The client would get some money. And or Sally Smith, yes, thank you. You pay back all or some of the financing proceeds. We're going to talk about what that is in a second. And what's the last complaint he has? His failure to reconcile the Kowalski's previous cost advances against funds received. Okay? So this can sound complicated off the top, but it's just like anything else, right? You do something, you have a business, you work, you buy something, whatever it may be, you've got costs. You got to pay the costs back. Now, different law firms handle this different ways. I'm not going to say one thing is right or one thing is wrong with how you pay back this person or that person or what agreements you have or what deals you have, okay? I know how we do it. I know what I think is right. And a lot of it just comes down to morality and ethics. And you got to make a call a lot of times in these cases. But he's basically saying that the money he dispersed, that Anderson dispersed, did not pay cost advances in certain funds appropriately. This is a big no-no. This is a big and major complaint that Greg Anderson is not going to take lightly. In response, okay, so this was on July 9th. He says that to Anderson. He's like, hey, here are the 3 things you're doing that I think are absolutely wrong and unethical. Mr. and Mrs. Anderson directed that my access to the firm's server and email be severed and terminated me. So I wonder if a wrongful termination lawsuit is coming. I don't know. It's tough for a lawyer, an at-will employee in somewhere like Florida. I don't know what their partnership agreement or what their contract was. They could have an employment contract. I don't know anything about that, but he's absolutely saying they terminated him in retaliation for his questions about these ethical issues. Given the intense public interest in the case, plaintiff's last known address, telephone numbers, and email address are not disclosed herein, despite the stated requirements for withdrawal found within Rule 2.505. Should the court require such information, the undersigned will supplement this motion with a confidential filing. Anderson Glenn remains counsel of record, along with Buell, Elegant, Ferrier, and Faircloth, PA. Accordingly, with undersigned, request that the court enter an order withdrawing Nicholas P. Whitney as attorney of record for the plaintiff. So he wants off this case. He wants off this case, and it looked to me at first glance like he wanted to wash his hands of the potential bad dealing of money in this case. And when we discuss wrongful termination claims like that, will it be called that? Probably not. But is he going to be owed money that he wants to fight about with Anderson? That's the real question, right? Is he... Somebody said there's a footnote. Oh, here we go. On July 23rd, I requested that Mr. and Ms. Anderson withdraw or correct their July 22nd motion for continuance. misrepresenting the circumstances of my departure from the firm. That request went unresponded to. Rule 4.3.3 requires candor toward the tribunal, an obligation that requires me to correct false statements of fact made to the tribunal. Okay? So here's what we have. This is Nicholas Whitney's position. Now, let's go to Anderson's response here. Make sure I pull up the right one, hopefully. All right, here we go. And you'll notice not a lot about his clients in that one, right? Not a lot about the Kowalskis in Whitney's motion. So let's hear how Anderson responds. Plaintiff Maya Kowalski, Jack Kowalski, and estate of Beata Kowalski buying through their lawyer hereby move this honorable court to enter an order striking from the record withdrawing counsel Nicholas Whitney's motion to withdraw. So they want it struck from the record. Why do they want it struck from the record? Do they not want him to withdraw? That doesn't make sense, right? Certainly seems like they're not working together. So why wouldn't he want to withdraw? Well, that's not what it is. And enter an order prohibiting him from any further filings, granting his withdrawal as grounds, therefore, would show unto this honorable court as follows. So they want the withdrawal motion granted, but strike that motion and don't allow him to file anything else, because we'll find out later, they do not want him to air their dirty laundry. That's what it comes down to. Here we go. This is what Anderson has to say. This is all something that should not be burdening this court, but plaintiffs must respond because the continuation of this hurts them. And when you've got the clients on your side and the clients with you, usually that's going to be important to the judge. He is, meaning Nicholas Whitney, no longer a shareholder, meaning a partner in the firm, and is no longer an attorney for the Kowalski family on any matters. The Kowalskis and their counsel have had no objection to his withdrawal. Okay? So that's not what the objection is. There was and is no need for this airing of dirty laundry in what should be a simple consent pleading. It was a waste of judicial resources and utterly irrelevant to bring this matter in the manner withdrawing counsel has chosen to bring it before this court. Withdrawing counsel has the plaintiffs leave, but moreover, encouragement to withdraw and leave them alone. So this is saying now, the plaintiffs just wish Nicholas Whitney would go away quietly. That's what this sounds like to me, that's what Anderson's saying. The Kowalskis and the undersigned apologize to this court for such issues even being brought before it. To his credit, even Mr. Hunter, meaning Howard Hunter, a lawyer for Johns Hopkins, no particular friend of the plaintiffs or their counsel, simply states, leave us out of this. Amen, Anderson says. So the court knows, withdrawing counsel failed to consult with counsel for the Kowalskis regarding release of information in his motion before filing it, but instead cited a conference with opposing counsel, specifically Howard Hunter, as the basis for revealing confidential information. So basically, Whitney talked about some stuff there. Maybe it didn't sound like it was attorney-client privilege, but we'll discuss whether or not maybe it is, right? Maybe it is. In this motion, the withdrawing counsel makes scandalous allegations against the undersigned counsel and the firm of Anderson Glenn. But in doing so, also reveals confidential attorney-client, work product, and accountant-client privilege and financial privilege information. The existence and the terms of certain funding devices used to repay the astronomical costs and fees incurred in preparing for twice, they had to prepare for this trial twice, and trying this case were and are confidential. Plaintiffs attach Exhibit A, which we're going to read, which is an affidavit of Jack Kowalski, who testifies in relevant part that the undersigned counsel has provided him with all the information as to all the costs, payment of costs, negotiations to reduce certain excessive costs, all disbursements, and all handling of money. There was and is no reason for these allegations, and especially to raise them in a public forum. The undersigned has and will live up to the rules regulating the Florida bar and each section regarding the ethics of handling a complex transaction. And frankly, the details are no one's concern but the Kowalskis. So there's a lot here. So we're going to pause for a second and discuss this. Hit the like button if you guys haven't already. So what is potentially attorney-client privilege from Nick Whitney's filing? And I've still got it up here. I'm not going to just keep switching them back and forth, but I believe Greg Anderson is saying that the fact that they are in receipt of settlement and financial proceeds, that there are cost advances and funds received, is confidential, either privilege between attorney and client. I don't know the answer to this because I wasn't involved in how he got this information, but potentially it could be. And let's talk for a second now about financing costs, funding loans, cash advances. Let's talk about that and how a lot of you guys know what those words mean and what those are, but how do they apply to a plaintiff's personal injury case? Okay. There are funding companies out there that primarily or almost solely promote and advertise and network and market to plaintiffs' personal injury lawyers and doctors. Why is this? Well, as we've talked about so many times, this stuff is expensive. And there are multiple ways to handle it. You, as a law firm, can either pay all the costs up front, and then you get reimbursed out of the settlement or the verdict at the end, all of those costs that you paid. So what are some of those costs? Well, there are printing costs. There are court reporter costs. There are deposition transcript costs. There are exhibit preparation costs. There are, if you want somebody to make you a chart or make you something that you can use at trial, there's a cost for that. If we hire an expert, there's a cost, and it's huge sometimes. We've paid some experts, $50,000 to go recreate an accident and go test something and go out and do all the measurements at a site, fly them out of town to a case. There are very expensive experts that law firms pay out of pocket. And then at the end, that's a line item that gets reimbursed. So that's one way to do it. There's another way. We've never done this personally, so I don't know what these contracts look like, but I know what they are, and I've had places try to sell this to me. And I'm not saying there's anything wrong with it per se, right? But there are funding companies that will come to law firms and say, let us pay that cost for you. We'll pay that $50,000, that $5,000, that $10,000, whatever it may be. We will pay that for your client. And then there'll be interest attached to that, of course, and we'll collect reimbursement at the end of the case. And that's a big deal sometimes, right? Because that can be years that these funding companies are just holding that bill. Years and years and years. There's no guarantee when a case is going to settle or when a case is going to go to verdict. There's also no guarantee you're going to win. Sometimes the clients still owe that money. Sometimes they don't, and it's a risk that the funding company will take. It's different depending on the contract and the funding company. There's not a one size fits all. All these companies do different things. They charge different interest rates. There's one thing in common. Usually it's a huge interest rate. Yes, Velo. This is in addition to the 33 1/3 or 40% if it goes to court like this case did. This is all in addition to the 40% cut, because you got to realize also these lawyers are working on this case day and night, not able to work on other cases for years and years, and then they still haven't been paid too. So, I mean, we don't have to get it. You guys probably know where I stand on the percentage for contingency fees, because if you lose, you don't owe the lawyers anything, even after all the work they've done. And lawyers take chances on a lot of cases, including this case. This was no slam dunk. So we're not going to get into, we've had that conversation before as a community, and I'd be happy to do it again on whether lawyer fees are too much or too little. I could guess about probably what most of you guys think, but we'll talk about that another time. I want to kind of focus on the funding in case anybody doesn't know how it works with, within a personal injury case. So costs, that's one way, right? These funding companies can advance costs, then you have to pay them back. Or lawyers can advance costs, and I don't know if some lawyers charge interest. I don't know if you can in some places. We don't charge interest. We just get the cost reimbursed, even if we hold it for 5 years. So it's obviously better if the lawyer does it, but there are some cases where there could be multi-million dollars in costs and a law firm can't do it and they've got to get a funding company. And it is what it is. So every law firm does it a little bit differently. But then there's funding loans based on the case and the case value. So there are different ways to do this too. And I'll tell you how we've done it in the past. I'll tell you how it can be done. In cases that we've done it, client is hurt. They can't work. They can't afford rent. So they have to take out a funding loan for rent. Lawyers aren't allowed to loan clients money in Florida. I can't be like, okay, here's $5,000. You owe me the money on the back end plus interest. Lawyers can't do that. But you may have guessed it, funding companies can. So they can give a client $5,000, huge interest rate. And we're talking huge interest rate. Sometimes you pay more than 100% interest on your money. It's crazy. So we always advise clients against it. It's a last case, worst case scenario. Do everything you can before you take a loan. I would say about 1% of our cases, maybe 2% of our cases have funding loans on them. And it's always the bare minimum. Whatever you can't live without, whatever's going to get you to the next month, and hopefully you'll be working. Because defense firms, they love it. That's why they want to drag these cases out. How long can this person live with an amputated leg and now he can't work? If we keep offering low, maybe he'll take it. If this person has a serious spine injury and they've had back surgery and they've had to be out for months and they've got a family, that's probably we're going to be able to discount it if they can't live. So sometimes funding companies come in and they fill that gap. Yeah, like I've seen some contracts where you pay back more money, more than twice the money that you got. So you get $1,000 and you pay back $2,400 at the end of the case, depending on how long the case goes. It's wild. When it first started, I remember it's wild. There are legal ways to do it. Okay. I don't run a funding company, don't have a funding company. We work with them as little as possible, but there are good funding companies. There are good people out there that have funding companies. So I don't want this to be disparaging of all funding companies, but there are some bad ones too. So you understand the psyche of why do these cases take so long, especially in civil court? Well, the defense wants to wait them out sometimes, even after they lose at trial. Woo, look at this. How do you think J-Hatch is responding to this? Now they're saying we want to stay out of it, but they're like, this isn't bad for us, probably. And if this case goes to trial a second time, they're not going to have Nick Whitney, who knows the case, knows the players, done some depots. So there are those funding loans, which I don't know if those happened in this case, but it sounds like potentially they did. And they can be for almost anything, pay your rent, groceries, whatever it may be, supplement your income. There are some companies that will just pay somebody whatever their income was every month, which those loans can get huge. We've never done it quite like that, but I know that exists. The only time we've ever done it is like specifically for rent or something like that for a month. I've never done one of these huge funding loan deals, but we have taken over cases as a second lawyer sometimes where that happens, and we've had to deal with it, and we've seen those contracts. And so just if anybody ever gets in an accident or has a case like this or has a case like this right now, just talk to your lawyer about it, right? Nothing I'm giving you is legal advice or how to do it. There's only one way to do it. Just talk to your lawyer. Make sure you understand what's going on. And that's a big part of this motion. Regardless of if you would do it or if I would do it, does Jack Kowalski understand what's going on? That's the big thing. So you've got costs, you've got funding the case, then you've got fees. Okay, this is also something we've never done, but just recently I had a case that we took over that a lawyer took an advance on fees. So if you say, I think this is going to be $1 million case, so my fee is going to be $400,000. Funding company, will you give me, $300,000 now, and I'll give you the $400,000 when we settle the case. And I'll just say, I don't like that stuff. I don't want to do that stuff. I'm not going to condemn other people that do it. I don't know their reasons for it. I don't know what those contracts look like. I'm just telling you from my perspective. Okay. We never have. I'm not going to say we never will or anything like that. I don't know what will happen in the future, but I don't like the idea of that personally. Okay. But sometimes it happens and you can get advances on fees from the funding company. And we don't really need to get into all of the issues with that, right, wrong, indifferent, whatever. It does happen sometimes. The most important thing is that the client knows what's going on. The client signs off on it. The client understands what's going on. Okay. And the advice their lawyer gives is between the lawyer and the client. Okay. So those are kind of three of the ways that the funding company can get involved. And Azam asked, Peter, this may be a dumb question, but what's a funding company? Is it an insurance company? So no, it is, in simplest terms, it's like a bank, I guess. It's a funding company. It could be me, right? And I have all this money in the bank. And I'm like, Azam, I'll give you $50. And 2 years from now, you got to give me $250 back. That's what a funding company does. There are contracts, the interest rates, compounding interest rates. If the case settles or goes to trial in 3 months, you might pay this, 6 months, you might pay that, 12 months, you might pay that. I don't know. Every contract is different. Sometimes it's just if you take a $50 loan, you get $100 back, whatever it may be. Okay. And I guess maybe they negotiate some of this at the end, he said, with some of these funding companies. I don't know. But that's what a funding company is. And those are the different ways it's used during personal injury cases. Only Plan said, shouldn't we start with Anderson's motion for continuance? Whitney's motion to withdraw was a response to a misrepresentation in that. So I didn't pull that one. I actually didn't read that. How long is it? If somebody sends this to me, I'll try to take a look at this one as well. I don't want to go back through the Sarasota Clerk of Court website, but if somebody sends me his motion to continue, I will try to at least skim through it to get what he said about Whitney in it. So when you have these funding situations, and here he mentions the existence and terms of certain funding devices used to repay astronomical costs and fees incurred for twice trying the case. So number one, costs could be cost of trial. It could be, printing paper costs. It could be internal costs, whatever it may be. Fees could be lawyer fees, right? Could be lawyer fees, or it could be expert witness fees. He doesn't say here, so I'm not going to assume it's lawyer fees. It could be expert witness fees as well. So it seems like some of this stuff is happening in the background of this case. So you can see potentially how this might be some kind of confidential or privileged information. Not necessarily, it might not be. These conversations could have been had, in a way that makes them not privileged somehow. But I think you can kind of see Anderson's point a little bit. All right, let's keep reading. Suffice it to say that the withdrawing counsel revealed the existence and extent of certain financial matters the clients wanted the firm, including withdrawing counsel, not to reveal or make public. And this is something I can understand. People are going to have problems with this and ask questions about it. And there are going to be some people that look down or get angry at the Kowalskis about it. I got to be honest with you. A lot of people have tough decisions to make. And when you're going through this for this many years, it's so expensive. It's overhanging your head. It takes over your life. It affects your work. It affects you mentally. It affects you physically. I'm not going to put myself in anybody's shoes and say, oh, I can't believe they did this. What they're going through is unimaginable since all this happened. And so many people that are plaintiffs in cases like this go through unimaginable things. And it's really hard to put us in their shoes. So I understand why they would have wanted to keep this confidential. All right. Somebody said they emailed me the motion. I will try to pull it up. All right. Let's keep reading here and then I'll try to. Hold on a second. Sorry. All right. Given the aggressiveness of opposing counsel at times, 5 depositions of the plaintiff, Maya Kowalski, and the general tenor of litigation, the plaintiffs did not want to make known they had to obtain funding to sustain them through the appeal. So we get a little nugget of information there, right? Because there's a lot of different ways and times you can get secure funding. You can do it at the beginning of the case. You can do it at the end of the case. You can do it in the middle of the case. It seems here that at least some of the funding came post-verdict. Why? Why is that important, Peter? Well, let me answer it for you. This is important because a lot of times, just like anybody else giving a loan, right? They want to know if you have the collateral, if you have the goods, if you're able to pay it back. And so my guess is maybe not a lot of funding companies were willing to give loans on this case before because it seemed like a very difficult case. It was not a slam dunk. But once you get a couple $100 million in a verdict, funding companies may see dollar signs and they may be more interested in giving loans. And Anderson says the plaintiffs had to obtain funding to sustain them through the appeal. So there's this other big delay. There is this other financial burden on them, even after a win, that most lawyers or most clients just don't understand and can't fathom. Wait, I thought the whole point was a jury system. The jury said we won. The jury said this much money. I don't understand why we're not getting any of it. And it sucks. And it's a hard thing for a lawyer to explain, but we have to explain it all the time. The court understands that knowledge is power. And if the defendant was made aware that the plaintiffs had to borrow money to be able to maintain the litigation, continue to pay costs, and otherwise sustain themselves throughout the course of the appeal, this is certainly relevant information that could affect settlement negotiations and leverage by the plaintiffs. So it's another good point. I already talked about how normally every defendant wants the plaintiff to get desperate, or they try to wait that out. If they know you're starting to get desperate, that's something that gives them leverage against you. The court, But that is all gone now because this withdrawing counsel has revealed all of this in a pleading filed as a matter of public record. And there was no reason for this other than personal avarice. The client has specifically refuted the factual allegations. Now that's a very bad thing for Nick Whitney. But, if they're still working with Anderson and not Whitney, everything I'm taking with a grain of salt. Okay. Just to be clear, I don't know who's right, who's wrong, who's going to win, who's going to lose out of this. I just know it's not good when two plaintiffs' attorneys start fighting like this publicly. The client has specifically refuted the factual allegations, and alleging all this without specific client authorization violates Rule 4-1.6 Florida Bar Rule of Professional Conduct. There was and is no basis for these allegations. Withdrawing counsel was very well compensated, even before this case is over. But it just wasn't enough for the withdrawing counsel. Those are major shots fired at Nicholas Whitney. He was very well compensated, but it just wasn't enough. You're going to call me greedy, Whitney. I'm going to call you greedy. That's what this sounds like from Anderson. This is not a basis to exert pressure on the Kowalskis or Anderson Glenn, revealing confidential information in a public pleading in a closely followed case. So after reading this, I'm just going to give you my guess. Okay. This is just my guess, just my opinion, not a fact. It sounds like if we're putting the context clues together, there was at least some kind of funding loan that covered some of the fees to the lawyers. And Nicholas Whitney got some of those fees. That's what it sounds like Anderson is saying. Well, it seems like Nicholas Whitney was like, hey, we got $10 million. I don't know what it was. We got $10 million as a loan on our fees or on the case or whatever it may be. I got $1 million or I got $500,000. Whatever it is that he got. I want to see the accounting. I want to see where every dollar of the $10 million went. Maybe that closing statement is more of what I thought initially. And it's not a funding loan closing statement, but it's the settlement funding attorney's fees closing statement that Nicholas Whitney wanted to see where every penny went. Because that's what we give our clients. In every case, there's a settlement. We say, all right, $100,000, $33,333 went to our trust account. $7,000 went to costs, repayment. $10,000 went to medical bills, and my math, I wasn't doing math in my head, but let's say $50,000 left over. That is what you get as compensation for pain and suffering, et cetera, et cetera. That's a closing statement. Every penny is delineated in there in every single case. You should and should absolutely get that in every case if you ever have a case of your own. Make sure you know where the money's going so you don't get Murdaughed, right? Or you don't get Girardied. Well, it sounds like Whitney was asking for this accounting because either he didn't trust that Anderson took the right percentage, whatever their agreement was, we don't know. He wants to know where the money went, which I think is legitimate. If he has a right to at least some of it, he should know where the money went. Seems like Anderson's like, you got enough. I'm the boss. Whitney's like, I didn't get enough. I have a say here. And that's where this fight came to a head. That's what it seems like, right? I don't know. I wasn't there, but that's what it seems like. And again, people are saying, I like Anderson, I like Whitney, whatever it may be in the chat. You guys can like whoever you want. I don't know any of them personally. I thought they did a good job with Maya's case. I've never had a case with or against any of them. So I'm just reading documents and trying to pick up the clues that they're putting down in these documents. That's it. It's nothing personal towards anybody. And I'm not even going to say who's right or wrong in this because I don't know what happened in the background, right? This is not a basis. Sorry, I already read that. It is hard to describe the level of harm inflicted on the Kowalski family. They want peace. They want an end to the controversy. They want to be left alone. That is the job of counsel, to protect the plaintiffs from any further unnecessary controversy. That is why the plaintiffs have burdened this court with a response. Finally, the withdrawing counsel has stated that he will be filing additional documents under seal, which he has not advised counsel for the plaintiffs directly or the Kowalskis indirectly through counsel of the contents. See, now it gets really sticky. It's like he's got to tell us so we can tell the clients, because he can't talk to the clients directly because they're represented by counsel, which is us and not him. It gets really sticky here. And there are actually certain ways where when lawyers and clients get in fights, there are certain things you can do to violate, to ethically reveal certain privileged things if certain accusations go back and forth, but we're not there yet. Plaintiffs directly, this is dangerous and violates Florida Bar rules of ethics and professional responsibility and conduct in multiple aspects. So they move this court to strike his motion to withdraw. They consent to his withdrawal and don't allow him to file anything else. So now let's go to Exhibit A, which is Jack Kowalski, the client, arguably the most important person here. What does he have to say? This is his affidavit that was attached. Before me, the undersigned authority personally appeared, Jack Kowalski. I am one of the plaintiffs in the above reference action, along with my daughter, Maya Kowalski, who herein adopts and agrees with my sworn testimony concerning the action of our former attorney, Nicholas Whitney, Esquire, and his filing of certain documents in this case. So Maya agrees with Jack, and here's what they have. I consulted with Mr. Anderson, and although I am not waiving any attorney-client privilege and stating in generalities, I directed him to keep the matter as confidential as possible. Again, talking about the funding loan. We know the court is aware of how contentious this litigation has been. This has caused tremendous stress and strain on our family. The 9-week trial and this aftermath, including attacks on Mr. Anderson personally, the statements made about us by the defense counsel and statements made in the media have added to the stress that we have endured over the past 7 years of this litigation and 9 weeks of trial. That's a long time, 7 years, to have this stuff hanging over your head. That's a lot of difficulty. That's expensive. These are issues that they have to deal with. All right, it looks like I just got the motion to continue, and I will read that next. We wanted the loan matter concluded as quietly, politely, and with as little stress as possible under the circumstances. So when they say concluded, I don't know if that means get their money, pay back the loan. There are still some unanswered questions here when we look through this. To that end, we have communicated virtually exclusively with Gregory and Jennifer Anderson. That's not good for Nick Whitney. On the post-trial matters, the appeal, and the handling of any of our financial matters. Because the notoriety of the verdict and the following of people in the media and private citizens, we wish to keep as much public attention away from us as possible. In particular, we did not want in any way any reference to any loans we took out or any perception of monies received by or through this litigation. I understand that we have a legal privilege against being forced to disclose financial information except under limited circumstances. By the way, it sounds here, and I'm not sure, but it sounds here like maybe he told Anderson he wants to keep it confidential, even maybe from Whitney. He's not saying that, but he said keep it as quiet as possible, keep it as confidential as possible. We didn't want to disclose any of this stuff. I don't know. I have been involved in the loan closing from the start and have been advised and kept aware of all aspects of the loan. I have reviewed the loan closing documents, the distribution of the funds, the negotiations to reduce costs, and all other matters regarding the fees and costs arising out of the suit. I have previously executed a client's statement of rights agreements for representation and explanation of fees. So again, statement of client rights is something that we put in every fee agreement in Florida. He's saying he's read that. He's saying he's been involved the whole time. He knows about the funds. He knows about the repayments. He knows what fees they're getting. And when he talks about repayment of costs, that might be repayment of costs to the law firm. Like I talked about, a lot of times law firms front that money, but they've been holding it for years and years and years. So maybe they got a funding loan to repay those costs, et cetera, et cetera. I receive regular bank statements, which are provided by both Anderson Glenn and independently by the bank. At all times, we know exactly where our money is and how much money has been dispersed for fees and costs for outside counsel. So there you go. That's adding another wrinkle. Are we even talking about Anderson Glenn? Are we even talking about Nicholas Whitney's fees? Or are they just talking about they had to get fees to pay appellate counsel? Maybe they're paying appellate counsel by the hour. Maybe they're not taking a percentage of the appeal. There's so much that could be involved in this, right? Maya and I have received and executed closing statements which had attached statements of outstanding costs, paid costs, and bank statements showing all disbursements. Mr. Whitney is not authorized to make any further statements about these matters to anyone, especially J. Hatch's lawyer. Again, that's not great, but it doesn't, it's not the end all be all, but it's definitely not great. It's probably the most important opinion in this case is Jack Kowalski's opinion. So, there was something I was going to say when we got here. Oh, so this is how you keep from getting Girardi'd or Murdaughed, right? You see all the statements, you're involved, you have to sign the bottom line of everything, and it sounds like Jack Kowalski has been doing that. And it sounds like he's been kept abreast of the situation. Jacqueline Weaver said, I'm home after breaking my hip, in the hospital for a month, getting around good, started PT. Keep me in your prayers, please. Jacqueline, I absolutely will. That sucks. I have heard that the hip is one of the worst parts of the body to injure and have surgery on and do rehab on, but you're going to crush it. You're going to crush it. We will be here. Come hang out. Come be in the lives. Come chat with us. And you will be in our prayers for sure, Jacqueline. John, I know Maya won, but could plaintiff side settle for a lesser amount if J. Hatch agrees to pay without appealing the case, just thinking outside the box? So John, you're squarely inside the box, my friend. No surprise, but you have the thought of every lawyer in America ever, right? This is exactly what happens. We go to trial, we win. It's this big, verdict, but a lot of times the settlement happens for less than whatever that verdict was. Not always, right? And it depends, but a $200 million verdict is probably going to end up being something less than that if they were willing to settle. It seems at this point like they are not willing to settle or not interested in settling, and so they continue on. All right. Before we get to the document I haven't read yet, let me read you a couple other ones here. First is this, just so we know what the judge is doing and what the judge thinks of all this. Order directing clerk to update plaintiff's attorneys. Attorney Nicholas Whitney is no longer affiliated with Anderson Glenn. The clerk is directed to update its case maintenance system to remove attorney Nicholas Whitney as attorney for the parties Maya, Jack, and Jack as PR of Beata. Previously on January 12th, the court dismissed plaintiff Jack Kowalski as parent of KK, a minor. To the extent the clerk's records reference former plaintiff, attorney Nicholas Whitney is no longer there. Clerk is directed to ensure the following attorneys remain on: Gregory Anderson, Jennifer Anderson, Raymond Elegate, and Amy Ferrier. Okay, so the court's in. They agree. Whitney is off. He's not saying who's right. He's not saying who's wrong. He's just saying Whitney is off. That's no surprise based on what, the client affidavit says. There's one other quick one here I want to show you, which just came out about a week ago, August 15th. By order of the court, the motion to withdraw as counsel for appellees filed by attorney Nicholas Whitney is granted. Attorney Whitney is relieved of further appellate responsibilities. Attorney Anderson, Elegate, and Ferrier, and Tanner, and Bell remain as counsel for the appellees. Okay? So Whitney is out. Court's ordered it. No longer responsible and no longer allowed to discuss this case on behalf of the Kowalskis. Now, no real surprise. It's what he wanted, and it was unopposed. But let's take a look at this, which I haven't read yet. Plaintiff's unopposed motion for continuance of August 1st evidentiary hearing comes now. Plaintiffs Maya Kowalski, Jack Kowalski, and Jack Kowalski's PR for Beata, by and through their unassigned counsel and pursuant to this court's order setting a hearing dated April 22nd, setting an evidentiary hearing for those motions directed to the imminent jeopardy report, and specifically states DIN 3597, plaintiff's motion for sanctions, DIN plaintiff's motion to compel supplement motion for sanctions, and plaintiff's supplemental motion for sanctions and consideration of bar referral for defense counsel's deliberate misrepresentation, and elicitation of false testimony and other conduct. Move this court to enter an order resetting the current hearing of August 1st to a date further into the fall, preferably in September, though November timeframe, September through November, and as grounds would show. Okay. So he's just asking for a continuance. They're dealing with these issues still, the sanctions, the IJ report, things like that. Okay. And here is the reasoning he gives for this, which I'm guessing is going to say something about Nicholas Whitney no longer working there. This past Tuesday, July 16, 2024, one of the attorneys from plaintiffs assigned to the case, Nicholas Whitney, left the firm without prior notice to, upon information and belief, practice at another firm. Okay. So we're going to keep reading, but assuming that this is it, and this is the reason he gave, this is so vague that it would be very hard for me or the judge or anyone to believe that this was so much of a lie and a misrepresentation that Nicholas Whitney had to come correct the record and say, I left for X, Y, and Z reasons. Because really all he says is you left to go practice at another firm, which if you're practicing at all, it's technically another firm, even if it's your own, right? Without prior notice, maybe he took issue with that. But again, didn't really sound like he gave a lot of notice. He said, I guess maybe he's saying Nicholas Whitney's left the firm and Nicholas Whitney saying, I didn't leave the firm, I was terminated. Again, to me, yeah, okay. Nosy Rosie is saying it's because he was terminated. Yeah. I'm catching up here. I'm catching up. So that's the big deal, is saying he didn't leave, he was terminated. Again, even if you had to terminate, if you're saying you terminate an attorney for cause, that could still be a reason for a continuance. So there will be a shareholder agreement that spells out exactly how shareholders get paid. You'd be surprised. You'd be surprised how fast and loose some law firms are. And just because you have a share doesn't mean you're an equal shareholder. And just because you have a share does not mean you're paid based on your shares. Okay. Let's keep reading. The undersigned has been in contact with the defendant, Johns Hopkins, counsel, and has explained circumstances, and counsel for the defendant, Howard Hunter, has graciously agreed that the defense does not oppose this motion only as to the fact the need for continuance, though obviously does not necessarily agree with the plaintiff's presentation of the facts surrounding the grievance issues. So even like your motion of sanctions, the defense is like, yeah, sure, continue it. That's how much the defense doesn't care about continuing stuff. The facts stated herein and below as to the grievance filing and timing are not agreed to by the defendant. They agree only to the fact that the plaintiffs will raise those issues and will plead them in a motion to be filed within a week. Counsel for the plaintiffs had planned for Mr. Whitney to argue portions of the motion involving physical evidence and documentary nature live at the August 1st hearing. So we didn't hear Whitney say, it wasn't true, I wasn't working on this, or I wasn't going to argue that, or whatever it may be. So I don't think he takes issue with that he was going to handle part of it. But what it does tell me is this happened quick. This happened quick. Because if at the time of this motion, which was when? July 22nd, they were still planning on Whitney handling a portion of this. And by July 24th, Whitney was out and filing that motion to withdraw, and he was saying stuff happened before July 22nd where he asked for accounting, maybe some money changed hands, there were issues, and it was fired. And this feels a little bit like an episode of Suits, if I'm being honest. Hearing to facilitate the marking of the evidence and the introduction of it before the court, the undersigned would argue the motion in its substance by Zoom from his summer home in Idaho, where he is currently taking his first vacation after the 9-week trial last fall of this case. It's like, I know people are going to be like, boo-hoo, you're taking a vacation in your mountain home in Idaho. But he's saying Whitney was going to be there to be my hands on the ground and boots on the ground and mark exhibits and move it forward. I was going to be arguing via Zoom. As a final basis, the undersigned, which is Anderson, has now inherited at least 8 new cases of which he was either unaware or had minimal contact in. So my guess is those are Whitney's cases. It had to be more than 8, but if he's saying, 8 new cases he's inherited because Whitney's leaving, that's what it sounds like. Understanding that they were being handled by a partner who is no longer with the firm. Okay, assuming that's Whitney. A cursory review has shown that these cases need a lot of work, subtle shot at Whitney, and the undersigned must now spend a good portion of his family vacation getting up to speed on these matters. These clients have the right to the successful presentation of their case, regardless of the undersigned circumstances. But in an attempt to cover for these clients' rights, the undersigned will be left without resources to prepare for the August 1st, 2024 hearing, which is of great importance. So it's like you kind of pile all this on, and I'll tell you, judges are apt to grant unopposed motions to continue. The vast majority of the time, they are granted. And by the way, I don't disparage him for taking a break. I think he deserves it. I think all lawyers should take some time off. Being a lawyer is the most stressful job probably on the planet. So take a break, go to a mountain home, relax, enjoy your family over the summer, over fall, whenever it is. I'm happy that they do that. I want to do more of that myself. Although none of this is this court or its judicial assistance problem, meaning my summer vacation or my new cases or my partner leaving, that's not your problem, it's my problem. Upon learning the full nature of the problem and scheduling issues yesterday, the undersigned immediately had his legal assistant contact the court's JA to give immediate notice of the issue. Plaintiffs hopes the court will consider the continuous attempts to minimize judicial effort where they could and to take those steps to assist the court in the effective resolution of the case. The plaintiffs and defendant are in agreement and both agree it would be better to reschedule the August 1st, 2024 hearing to a date certain in the latter part of September or October 2024. So not a huge continuance either. And this is not the stuff that is as pressing as a trial or things like that. The plaintiffs and especially the undersigned apologize to this court and to the court's JA and clerks for the inconvenience this may have caused. Counsel is prepared to consult regarding the matters which will ultimately be heard. What's funny about, the way Anderson writes his motions is it's so, it's just like a conversation. It's conversational. Like literally I can hear him say this stuff. It's as if he's saying it, which is always funny. All right. And I believe this motion was already granted. I'm not positive, but I believe this motion was already granted. If it hasn't been granted already, I would expect it to be granted. Kelly said, Peter, do you use LOPs in Florida? So there are certain doctors that have in the past. We don't like to. We don't. LOPs are certain agreements between doctors and lawyers that they'll get paid at the end of the case. There are all sorts of different ways that doctors get paid. And the medical billing is just so hard in the world where you don't know what it's going to cost when you go in the hospital, but you have to go. You don't know what an MRI is going to cost at this place versus that place. It's so unfair to clients. So, insurance is billed in some cases, Medicare, Medicaid, supplements, out-of-pocket payments, or like these funding companies, sometimes doctors' offices will just hold the bill open until the end of the case and get paid out of the settlement or the verdict proceeds. With Whitney being off the case, is he still entitled to all of the fees he was owed originally? Correct? Yes. So he is entitled to whatever he was entitled to at the time. Now, what's hard about that is if they go to a second trial. What did he actually produce, right? If this verdict gets overturned. If there is a settlement that Anderson's firm is the one that has to do all this extra work to get that settlement, what is or is not Whitney owed? And that may be something a judge has to determine in the future. I don't know. I don't think this conversation is over. And a lot of times when $200 million are at stake, this is what happens. It's tough. It's tough. But hopefully you learned something today. A lot of background, a lot of behind the curtain, behind the scenes stuff of how this works. So many people think, oh, big verdict. Oh, so sad. J Hatch has to pay this money. It's like, yeah, for the most part, it's not how it works. That's why as plaintiffs, lawyers, and as plaintiffs, you fight. A lot of cases settle because that's guaranteed money for the client. And then a lot of cases you have to go to trial just to get the leverage to settle later. And juries usually think, oh, this person's money hungry. But a lot of times the defendant's either offering nothing or way less. And you have to go prove it before they even offer anything reasonable. And of course, there's both sides, right? There's good cases and bad cases and good lawyers and bad lawyers. And there are frivolous, fake lawsuits. And there are really good lawsuits that defendants don't believe. So it really depends, but from my perspective, this is sad. I hate to see this happen. I wish it didn't happen. But I want to explain it to you guys so you guys understand. And if you ever have cases like this or work with lawyers or have PI cases, you can call us, of course. We'd love to help you with it. This is what we do. This is our expertise. But I want people to be aware of their rights, right? I want people to be aware of what's going on. I don't want people to do things blindly. I don't want people to get murdered or Gerardied. Okay? I really hate to see that happen. I despise it. But that's all we got until, this is a good question. Sorry. Are there non-compete clauses in contracts for lawyers? So this is very interesting. In Florida, no, there's not non-competes. You can't tell a lawyer that he can't compete in a certain area or practice area as you. But whenever a lawyer leaves the firm, you're supposed to write a letter notifying the client and letting the client choose which lawyer they go to. Now, you can have contracts with lawyers that say, if you leave, we'll continue to handle the cases and I'll give you 25% of the fees or whatever it may be. You can have kind of contractual agreements, or you can even sign a settlement agreement when a lawyer leaves, but no non-competes. All right. That's all I got, folks. Hit that like button, please. Make sure you subscribe to our channel and let me know if anything else pops up in this case you have questions about. But until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a page you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.